Can the victim of a criminal offence just drop the charges? Usually, no. Or more precisely, they can ask for the prosecution to stop, but they can't simply command that it stops. And this is by far one of the most common misunderstandings that I see in criminal law. Because somebody reports an allegation, police investigate it, and a person is charged. Everybody knows this. Well, sometimes. But then a week or a month later, the complainant might say something along the lines of, "I don't want to proceed anymore, I want to drop the charges." I've called them the victim there because that's the language people commonly use. But before the court's made a finding of guilt, the more accurate term is complainant, or the alleged victim. And the important point is that the complainant doesn't actually own the criminal charge process at all. And the first place that you can tell is by looking at the name of the case. In the local court, it will usually be the police and the accused person's name. In the more serious matters, it's the king and the accused person's name. It isn't the complainant against the accused. And that's important because it really shows you who owns what side of the process. And that's because a criminal prosecution is actually brought by the state on behalf of the community. The complainant may be the central witness. They may be the only person who suffered anything from it. But their evidence may be the reason that the prosecution even exists, but they aren't the prosecutor's client, and they aren't the prosecutor. And I used to prosecute criminal matters for the police, and I now defend people charged with offences. And on both sides, this question comes up constantly, but they don't want the charges anymore. That matters. It just doesn't decide the case by itself, and there's a fairly obvious reason for this. If a prosecution automatically ended whenever a complainant said, "I don't want to proceed," then enormous pressure could be placed upon complainants to say exactly that. The accused might pressure them. Family members might pressure them. They may be financially dependent on the accused. There may be children involved, or the complainant may be afraid of what happens if the case continues. All of those are reasonable fears. Or they may have simply reconciled and genuinely no longer want the person prosecuted. That happens too. It actually happens a lot. The system can't assume that every reluctant complainant has been intimidated, but it also can't assume that the change of position has occurred freely. So the prosecutor has to assess it. And in New South Wales, depending on the type and stage of the matter, that may be a police prosecutor, it may be the officer who charged, or the Office of the Director of Public Prosecutions. The complainant's views should be heard, and they should be taken seriously. And in DPP matters, the prosecution guidelines expressly say that the complainant's views must be considered, but that they are not determinative. They're not the final say. So in plain English, their wishes matter, but they don't get a vote, not the final vote. The prosecutor still has to consider whether there's a reasonable prospective conviction on the admissible evidence and whether continuing the prosecution is in the public interest. So what actually happens when a complainant says they want to withdraw? Well, police will normally want to speak with them. Why have they changed their mind? Are they saying the original allegation was false? Are they saying that they don't want to be involved because they don't want the accused punished? Are they worried about giving evidence? Has somebody contacted or pressured them? And those are all very different situations. A person can give police a further statement explaining their position or retracting their earlier one, but they can't withdraw an earlier statement in the sense of making it disappear entirely. It'll always be there. It doesn't just get torn up and removed from the file entirely. The earlier account will remain part of the investigation, and any difference between the accounts will need to be considered. But there's another misconception here. The fact that police possess a written statement does not necessarily mean that the prosecutor can simply hand the statement to the magistrate, or judge now, if the witness refuses to attend. They still need to turn up. And ordinarily, what somebody said outside of court is hearsay. Hearsay meaning evidence of something said outside of the courtroom that's being used to prove the truth of the words that they used, of what they said was true. Now, there are exceptions, and there's quite a few of them actually, and evidence law didn't miss an opportunity to become complicated. It almost never does. It's part of the reason it's so fun. But generally, If the prosecution relies upon a witness's account, the defence is entitled to test that account through cross-examination. And that means the complainant may be subpoenaed. In fact, the usual practice is that the complainant is subpoenaed. And a subpoena is a court order requiring somebody to attend and give evidence. There are exceptions. There are separate rules about whether particular witnesses can be compelled. But simply saying, I don't want to come, does not necessarily end the matter. If a witness does attend court, they aren't required to repeat an account that they now say is false. They are required to tell the truth. And if their evidence changes, the prosecutor may ask them about the earlier statement. The court may hear evidence about when it was made and why the account has changed. And then the judge or the jury decides what evidence, if any, can be safely accepted. I say judge or jury because it depends on what stage of the proceedings you're at. Don't worry about it. It's not the point of this video. Sometimes the prosecution doesn't need the complainant's evidence to continue, which might sound absolutely insane, but there may be another eyewitness. There may be photographs, medical evidence, text messages, or admissions made by the accused in an interview. In addition to that, police body-worn video may show the scene, the injuries, the condition of the people present, or something said when officers arrived. A 000 recording may also be relevant, although whether an out-of-court statement can be actually used depends on the rules of evidence. In New South Wales domestic violence matters, for example, a complainant's recorded statement to the police can sometimes be used as their evidence in chief, meaning when they give their account. Evidence in chief is simply the first part of a witness's evidence, where they tell the court what they say happened. But that recording isn't a magic replacement for the entire witness. The complainant will ordinarily still have to be available for cross-examination and potentially re-examination. So the prosecutor has to examine what evidence can actually be placed before the court, not merely what exists in the police file, in the brief. If the complainant won't support the prosecution and there's no other admissible evidence capable of proving the offence, then the prosecution may be discontinued. Equally, the prosecution may treat their witness, the complainant, as a hostile witness, an unfavourable witness, and they may cross-examine them. But that decision belongs to the prosecution. On the other hand, if there's strong independent evidence, the case may continue even though the complainant is asking for it to stop, sometimes even if they don't turn up. The seriousness of the alleged offence matters, and so does any history of similar conduct, the safety of the complainant, the reason for their reluctance, and whether the case can be proved without requiring them to give evidence. Now, changing your account isn't automatically a criminal offence. And I know a lot of people are probably thinking this. Isn't that perjury? People make mistakes. They remember further information. They may want to clarify things. And sometimes an initial statement was inaccurate. But there's a difference. Because deliberately giving police false information or knowingly giving false evidence to a court can create entirely separate problems. The lawful option is always the unremarkable one. Tell the truth as you remember it. And if you're the person accused of the offence, do not contact the complainant and ask them to withdraw the charges. There may be bail conditions or an apprehended violence order preventing contact, and even where there isn't, attempting to pressure a witness is a one-way ticket to further criminal proceedings down the road. So can the victim drop the charges? They can tell police or the prosecutor that they don't want the matter to continue. They can explain why. They can give their position, which may materially affect the evidence and the decision about whether the prosecution should proceed. But they don't have a legal button marked drop charges. Television has given that phrase a remarkably successful career, mostly American television. In reality, once a person has been charged, the complainant is an important participant in the case. But they're exactly that, a participant. The prosecution still belongs to the state. And the final decision about whether it continues belongs to the prosecutor, not the complainant. Hopefully that cleared it up. If this is the sort of thing you enjoy, you know what to do. Get your questions in. I'm James Glissan, and I will see you in the next one.